Hi, I'm Shan Wu with a Undercolor of Law hot take on the differing stories from Justice Alito about his habit of flying flags, some upside down. So Justice Alito wrote a letter to Congress in which he explains to them that he was going to refuse to recuse himself from cases involving Trump or the January 6th uprising, because there's been a lot of questions about the fact that at his house in Alexandria, Virginia, there was a United States flag being flown upside down, which is today a distress signal associated with the January 6th uprising, stop the steal kind of symbol. And in addition to that, in his beach house, there was another flag dating back to the Revolutionary War entitled the Appeal to Heaven flag. Now, both of these are certainly enough evidence to raise the question of, can he be impartial in these kinds of cases? But what he wrote to Congress was he was refusing to recuse himself. And in the letter, he gave some factual statements that could cause a problem for him. Those statements were carefully worded, as we'll discuss, but he references the upside down United States flag, saying that's something that his wife did, and that it was in response to a confrontation with a neighbor. He describes that confrontation pretty clearly, and we'll put up his description of it for you to take a look at. And he describes it as a man having a confrontation with him and his wife, and the man calls his wife, a curse word. And he's suggesting that it's this reaction to this confrontation that causes his wife to fly the flag this way. Here's a problem. On CNN, the neighbor who had the confrontation, a woman, talks about what happened. And her version of it is pretty different. So take a listen to this.
Because you said those things. But when we look at, there was actually, you called 911 on that day. There's actually a police report about that incident. And that shows that the timing just doesn't work, right? The flag was up before. The flag picture that the New York Times had was weeks before that incident actually happened, where you called her that word. So what he's saying here, you're saying at best mistaken, but it certainly is it's categorically by the dates not true, right? She didn't put the flag up for that reason.
Absolutely, 100%. And that's what I want to really drive home to people, is that this happened on February 15th. And we know that because they had been harassing us so long that we were like, we need a paper trail of this. Like, we better call the cops right now. Like I said, these are federally protected people. They have security detail. They represent the judicial system. They are the law. And I am just a regular person. And so it's, we called the cops that day. It was February 15th. And I think the photo of the flag was on January 17th.
Yes. The timing doesn't add up. I do think.
So in her version, there's some big discrepancies, right? First of all, she says that it was her that uttered this curse. She's not proud of it, but she was the one that did that. And also that it happened much later than the dates that the media is reporting the flag flew. There's a photograph of that flag flying upside down on January 17th. According to the neighbor, this confrontation happened February 15th. So that's quite a while that the flag is flying. And according to Alito's letter, he makes it sound like he just didn't notice it. I mean, it's a long time for the flying upside down for him not to notice that. The other thing that would be of concern to looking at his letter with a prosecutor or an investigator's eye is it's really interesting how carefully worded it is to avoid him locking himself into particular dates in the letter. He actually references the media reports about the upside down flag flying incident. He doesn't say on such and such a date this happened and that he noticed the flag flying on a certain date. If he thinks that keeping it that vague would keep him out of hot water because making a false statement to Congress, 18 U.S.C. 1001, is a problem, it's a criminal violation. If he thinks that keeping it that vague is going to keep him out of trouble with that, He's probably wrong on that point because he's still trying to mislead Congress if that's what he's trying to do. And those are pretty material discrepancies. But you know what's even more interesting about that? It shows he's trying to keep it vague. He's trying to perhaps avoid any jeopardy for himself here on liability while walking this fine line of portraying a sympathetic situation involving his wife, kind of standing up for her right to have a reaction to something by flying this flag. That kind of effort, that sort of wordsmithing by all accounts, a very sharp lawyer, that should raise a big red flag for both congressional oversight as well as for the Justice Department. The Senate really should just subpoena him to testify about this. And DOJ really needs to open an investigation, as I've discussed before. There's too much timidity at DOJ about opening an investigation into Supreme Court justice, ethics, behavior, because they seem to think that merely opening the investigation makes it seem as though they're being partisan or that they're accusing the justice of doing something wrong or illegal. It's just an investigation. That's how you find the truth out about matters, and that's why they need to do that. So if they open the investigation, the neighbor can be interviewed, not just on TV, but by FBI agents. They can lock down this timeline, and then the justice, if he doesn't invoke the fifth, should answer why there are these material discrepancies. Now, also involved in this is the concept of separation of powers, and it actually goes to this issue of both Congress being perhaps too timid to subpoena and DOJ not opening the investigation. Congress may be concerned, there are political reasons they're worried about subpoenaing or compelling a Supreme Court justice to try to testify, but probably what they are also worried about is the separation of powers idea, which actually the Supreme Court has rather cleverly indoctrinated us about, not to teach us about the separation of powers, but to indoctrinate us to use the concept as a shield against ever holding the Supreme Court, or rather its justices, accountable. Congress may be thinking, okay, what if we subpoena him, Justice Alito, or Roberts, and they just refuse? They blow off the subpoena. How are we going to enforce that? It's going to go to the courts, they're thinking, and eventually ends up before the Supreme Court. The Supreme Court says, we're going to rule against you in favor of ourselves. So there's kind of a sense of it can't go anyplace because of that. That's not the separation of powers. That's not how it's supposed to work. The separation of powers just says that you've got three branches, they have different powers, and they're separated. So the Supreme Court, the judiciary generally, doesn't make laws. Think about that. Congress doesn't enforce them, meaning it doesn't go out and arrest anybody. And the judiciary doesn't do that either. That's kind of a rough breakdown, right? So it's invoked a lot. Justice Roberts declined to testify about the Alito matter. And in his letter, which we can put up to Congress, he actually says the quiet part out loud. He says, quote, justices decide for themselves when to step aside. Now, recall there's a actual U.S. law, 28 U.S.C. 455, that says any judge, magistrate, and any justice, specifically Supreme Court justices, shall disqualify himself if it's reasonable to question their impartiality. But what Justice Roberts is saying is that law doesn't apply. Okay, that's the law that Congress passed. He is the head of the federal judiciary, and he's basically removing that law. He's saying that law can't apply to us even though we're justices. His notion for why he can say that, it's the separation of powers. But that's not how it's supposed to work. There actually is a lot of interaction between the different branches. So, for example, if Congress passes a law, and let's say it's a new particular criminal law, and DOJ doesn't like it, they don't want to enforce that law, they think it's unfair, maybe it's discriminatory, they can't actually challenge the law in terms of the way it was created or legislated, but they have something called prosecutorial discretion. They can decline to bring cases using their discretion. That discretion, that's within their core functions as the executive branch. The justices can't challenge that. They can't say, hey, you used bad prosecutorial discretion in not bringing this case. That's something unique for DOJ, and under that unique aspect of their powers, they can open an investigation. The justices can't say you cannot open an investigation into a Supreme Court justice because that violates separation of powers. That makes no sense because that's what the executive branch can do. Similarly, Congress can pass a law and the Supreme Court can strike it down. The Supreme Court can say this is an unconstitutional law. Something wrong with this law. That's a core part of what the Supreme Court does, is it decides constitutional issues. Congress cannot then say to the Supreme Court, you are not allowed to strike down our laws. The Supreme Court can't tell Congress this is how you legislate the law because you didn't draft it correctly. But they can opine on the constitutionality of the law. Now, what happens after the court says, this law is unconstitutional, something's wrong with it, we're striking it down? Congress has recourse. They can't challenge that ruling. They can't say, oh, your ruling's wrong. You got it wrong. It's unconstitutional. We challenge your core ability to make judicial decisions. No, they can't touch that. What they can do, and this happens a lot in Supreme Court arguments, an advocate or the justice will say, look, this law is wrong. It's unconstitutional, but Congress could do something. What can they do? They can go back and they can rework the law. They can react to a Supreme Court decision, striking down some aspect of the law, and then they can go back and re-legislate it, come up with a different idea. I bring all that up to show that the separation of powers just means that there are separate powers that the three branches accomplish. It does not mean that each branch is completely untouchable and can do anything it wants as long as it claims that it's acting within its core. That's the problem with what's happening right now with the Supreme Court. Justice Roberts is basically saying, because we are the Supreme Court in the United States, the justices on that court cannot be scrutinized. You can imagine that he won't even allow testimony or come to Congress to talk about ethics issues. Can you imagine what his reaction would be if a justice was actually charged with something? Under this logic, he would say, that's unconstitutional. You can't charge a Supreme Court justice because that violates separation of powers. That does not make any sense. And whatever Chief Justice Roberts' intentions may be, and let's give him the benefit of the doubt, he's an honorable man, he's trying to protect the institution, that's a misunderstanding of how democracy works. That's a misunderstanding of how the Constitution is supposed to work, and he needs to be corrected on that. That's it for now. I'm Shan Wu. Thanks for listening, thanks for watching, and keep the comments coming because it's really great to read them and get the feedback from you as to the kind of topics and how to cover them. Thanks. Talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.